The board's oversight is crucial for effective CSR implementation. By law, every covered company must spend at least 2% of the average net profit of the last 3 financial years on CSR activity. For newly incorporated companies, the calculation is based on the average net profit of the years actually completed. This spending must align with the approved CSR policy and be on activities specified in Schedule VII. Law encourages companies to give preference to the local area and areas around where they operate when selecting CSR projects. While not mandatory, this preference helps ensure that communities directly impacted by the company's operations benefit from its CSR initiative. If the required CSR amount is not spent, the board must specify the reasons in the board's report. Unspent amounts not related to ongoing projects must be transferred to a government-specified fund within 6 months. For ongoing projects, the amount must be transferred to a special unspent CSR account within T days and spent within 3 years. If not spent, it must then be transferred to a Schedule VII fund. If a company spends more than the required 2% in a financial year, the excess can be set off against CSR obligations of the next 3 years, provided the board passes a resolution approving the set-off. However, any surplus arising from CSR activities must be reinvested in CSR and cannot be treated as excess spend. Net profit for CSR purposes is calculated as per Section 198 of the Companies Act, not as per the Income Tax Act or simple accounting profit. Section 198 provides a specific method, including certain inclusions and exclusions, such as capital profit and revaluation gain. This ensures a standardized approach to calculating CSR obligation. Failure to spend the required CSR amount, transfer unspent funds within prescribed timeline, or comply with CSR provisions can attract penalties under Section 135(7). Both the company and its officers in default may be penalized. The law now prescribes only monetary penalty, not imprisonment, making compliance a financial imperative. Section 135 governs unspent CSR amounts relating to ongoing projects. An ongoing project is a multi-year project with a timeline not exceeding 3 years, excluding the year of commencement. If funds remain unspent at year-end, they must be transferred to an unspent CSR account within T days and spent within 3 years. If not spent, the amount must be transferred to a Schedule VII fund. Once transferred to the unspent CSR account, the company must spend the amount within 3 financial years on the ongoing project for which it was earmarked. This ensures that CSR commitments are eventually fulfilled and not indefinitely deferred. If the amount is not spent within 3 years, it must be transferred to a government-specified fund. Board must disclose details of unspent CSR amounts in the board's report, providing project-wise detail in the annual CSR report. Proper monitoring and documentation of utilization are essential. Non-compliance with transfer timelines may attract penalty, reinforcing the importance of timely and transparent reporting. Practical compliance flow for CSR is as follows. Calculate the 2% CSR obligation. Identify any unspent amount at year-end. Determine if it relates to an ongoing project. Transfer to the unspent CSR account within T days if applicable. Spend within 3 years, and if not spent, transfer to a Schedule VII fund within T days after the 3rd year. This structured process ensures accountability and prevents indefinite parking of C. Section 135(7) prescribes penalties for non-compliance with CSR spending or transfer requirement. If a company defaults, it is liable to a penalty of twice the untransferred amount or 1 crore, whichever is less. Officers in default face a penalty of 1/10 of the untransferred amount or 2 lakhs, whichever is less. These penalties are civil in nature and are adjudicated under the Act. Penalties for CSR non-compliance are civil, not criminal. There is no imprisonment, only monetary penalty. This shift, introduced by recent amendments, emphasizes financial accountability rather than criminal prosecution. The aim is to encourage compliance through financial consequences rather than punitive measures. Default arises if a company fails to spend the required 2% on CSR, does not transfer unspent amounts related to non-ongoing project to a Schedule VII fund within 6 months, or fails to transfer unspent amounts for ongoing project to the unspent CSR account within T days. Timely compliance is essential to avoid penalty. Under Section 135, the central government can issue general or special directions to ensure CSR compliance. These directions may relate to implementation, spending, transfer of unspent amounts, or reporting. Companies are legally bound to comply with such directions, and failure to do so may attract penalty. Power to issue directions allows the government to address implementation gaps, clarify ambiguity, and ensure that CSR funds are properly utilized. This supervisory safeguard strengthens accountability and helps maintain the integrity of the CSR framework. Section 135 No provides that if a company's CSR obligation does not exceed 50 lakh in a financial year, it is not required to constitute a separate CSR committee. Instead, the board of directors directly performs the functions of the committee, including formulating policy, recommending expenditure, and monitoring implementation. And exempt from forming a CSR committee, the board must still ensure that the do Pratishat spending obligation is met, reporting and transfer requirements are fulfilled, and all statutory disclosures are made. Only the structural requirement of a committee is relaxed, not the substantive CSR obligation. The SR activities must be chosen from those listed in Schedule VII of the Companies Act. These include eradicating hunger and poverty, promoting education, gender equality, environmental sustainability, rural development, disaster management, and contribution to government relief funds. Companies should align their CSR initiatives with these approved areas. The terms under Section 135 include net profit, calculated as per Section 198, not the Income Tax Act, and average net profit, which is the average of net profit over the last 3 financial years. Every company refers to any company incorporated under Indian law, including foreign company with a business presence in India, provided they meet the financial threshold. Step-by-step compliance matrix helps companies navigate CSR obligation, check financial thresholds, constitute a CSR committee, if required, formulate and approve CSR policy, allocate and spend at least 2% of average net profit, implement approved activity, monitor and report progress, and handle unspent amounts as per the law. This systematic approach ensures full compliance. SR obligations are governed by several sections and rules. Sections 242, 257, 291, 134, 135, 198, 381 and Schedule VII of the Companies Act, along with the Company Corporate Social Responsibility Policy, Rule 2014 and Secretarial Standard 1 Companies must also file an annual report on CSR activity with the board's report. Main objective of Section 135 is to ensure that profitable companies contribute to social development, inclusive growth, and environmental sustainability. By making CSR a legal obligation, India aims to channel corporate resources towards nation building and societal welfare, setting a global example for responsible business conduct. Summary: Section 135 of the Companies Act 2013 establishes a robust framework for corporate social responsibility in India. It sets clear financial thresholds, mandates spending, requires structured governance, and enforces compliance through reporting and penalty. Whether you are a domestic or foreign company, understanding and following these provisions is essential for legal compliance and positive social impact. Thanks for watching, and remember, responsible business